Yes, let's start the class. So we were discussing law of torts, okay, and in the law of torts, we are going to start with the topic that is negligence, okay. तो यस थोड़ा बहुत तो बताया भी था मैंने आपको नेग्लिजेंस कुछ होता है कि बेसिकली इट इज समवॉट lack of due care, okay. So what happens is the law basically expects from everyone that they will basically perform all the actions with due care, and carefulness must be there, okay. So carefulness must be there with due care, caution, all right. And it is generally expected by everyone in the society that in the society every reasonable and a prudent person must basically, what they must do, they must perform every task with due care and caution, all right. So now here comes the main thing, that when can we call any particular action as being a part of negligence, all right. So when we will call it, I have basically three things here, okay. The first, when is basically a particular act or a particular action will be categorized as negligence, all right. So that's the very important point where we have to basically distinguish the actions that will not be categorized as negligence and the actions that will be categorized as negligence, all right. So the first thing that is there must be a legal duty on the individual, all right. What must be there must be a legal duty on the individual to take due care, all right. So what is the meaning of this? This means that, for example, on a doctor there is a legal duty that the doctor must take due care and caution while performing his basically anything whatever a doctor do, okay. Maybe while performing surgery, maybe while prescribing any medicine, or basically maybe when carrying out any procedure. So it is the legal duty of a doctor to to take all the due care and caution, and to basically take all the precautions, to be very careful, okay. So the first requirement for calling any action or a act as negligence is basically there must be a legal duty, all right. तो negligence तभी हो सकता है when there is a legal duty. Got the point? Now second thing must be that this legal duty must be breached. So we will call a particular act to be negligent when there lies a legal duty to take due care and this legal duty is breached. And when this legal duty is breached, what will be the resultant? The resultant is injury or damages. All right. So that means these three things must be satisfied to call any particular act or a action as being negligent. That is, there must be existence of a particular legal duty to take due care. That legal duty by any action is breached, and that breach has resulted in any injury or damages. At that time, this particular act or action will be called as negligence. All right. So,
सर एक
sorry.
डाउट था कि
हाँ हाँ
सपोज सर एक लीगल ड्यूटी है वो ब्रीच हो जाती है बट उसके जो रिजल्ट होता है वो इंजरी या डैमेजेस होते नहीं है तो उसे नेग्लिजेंस में नहीं डालेंगे फिर
देखो, अगर हाँ कुछ अगर ऐसी लीगल ड्यूटीज हैं, ठीक है, देर आर सर्टेन legal duties, okay, the resultant, the breach of that will definitely result into the particular tort, even if that has not resulted in any injury. तो वो लेकिन बहुत exceptions होते हैं, वो बहुत minor चीजें, बहुत बहुत छोटे कैटेगरी में आते हैं, बहुत कम है वो, है ना. later on, while basically discussing the later parts of negligence, we will be discussing about those kind of things, those kind of negligence. But here in the majority of the cases, okay, for example, a bike rider is there, a car rider is there, and he has a legal duty to basically drive that particular car under speed and not to overdrive in a crowded area. That's the legal duty on that person who is basically driving that car or motorcycle. Now he breached the duty, which resulted into injury to any person, all right, to any person in that crowd, or any other particular form of injury. Now that will be categorized as negligence. But now that person has basically driven in a very high speed, okay, he has basically started driving that car in a very high speed, even if the injury has not resulted. Now that will be an offense, obviously that will be an offense, all right. It's not like that thing will be excluded from the category of offense, but basically to call a particular tort for उसको रेमेडी देने के लिए, है ना, if someone basically comes asking for a remedy, asking for a compensation, okay, if you go to the court and basically calls that this act of X person was negligence, now there you will have to prove that what sort of damages or injury has happened to you, okay, in lieu of which the court must basically sentence that particular compensation or injunction, all right. So for that you will have to prove that, okay. But in itself that wrong is a wrong, obviously, all right, even if there is no as such damage, okay. So now, right, what are the essential elements of negligence, okay. So this is the question, that what are the essential now from your question only, anywhere, wherever you find a blank space in your notebook, you can write one thing: without damage, okay, without damage, negligence is actually not actionable, okay. You cannot take any, the court can in turn take cannot take any action if there was no actual damage, okay. All right, so have you written the question, what are the essential ingredients of negligence, all right. So right, the first, write the first point, that is duty of care, duty of care. So duty of care means it was your duty. It was your, not just a moral duty, but a legal duty. So that means it was your legal duty to take reasonable care. Okay. So now you became carelessness and you basically abridged a legal duty that was there on you. All right. So now write this thing. Duty of care means, duty of care means a legal obligation. It is not a moral obligation, it's a legal obligation, all right. Means a legal obligation imposed on a person, imposed on a person to take reasonable, to take reasonable care to avoid causing harm to others. Okay. So that means there must be existence of a particular legal duty, okay. And on the other hand, the duty must not only be a social or a moral duty, okay. That must be a legal duty. You can write also, it must be a legal duty and not a social or moral duty, okay. It must be a legal duty. it must be a legal duty and not merely a social or moral duty, and not merely a social or moral duty. Okay. uh, and basically you there must be that in case a plaintiff basically comes, to the court. Okay, now this must also be proven by the plaintiff that the defendant owed that duty to this plaintiff. All right. Now, for what does this mean? This means, for example, X was a patient and Y was a doctor. Now, doctor, so the allegation of this person on this doctor, the plaintiff basically is is putting an allegation on the doctor that the doctor, while basically doing any procedure on the patient, on him, basically negligently did his act. Okay. Now, he will have to prove this thing also, that this doctor owed a duty to this particular patient, that is the plaintiff. Okay. Now, any random A person whom this doctor was not owing any duty, okay, any legal duty, they cannot approach to the court demanding any sort of compensation or damages. All right. It must also be proved that they owed a duty. Okay. Is it clear? Now, coming on to next point, write some examples also. A doctor owes duty to his patient. A doctor owes duty to his patient. One more example also, a driver of a car owes duty to other road users. A doctor owes duty to other road users. Okay, is it clear? All right. So now the next thing is that the next component is that there must be a breach of that legal duty. Just mind, whenever we are writing duty, it's a legal duty. We are talking about a legal duty. All right. So now write. All right. Breach of the duty occurs. When does it occurs? Right. Breach of a duty occurs when the person fails. When the person to meet, fails to meet the standard of care which is expected from a reasonable and prudent man. Okay. So the society and the law, leave society, but the law basically expects from every reasonable man and a prudent man to basically carry out any particular act in a certain standard way. Okay, certain way with due care and caution. All right. So now, right, the test for breach is, now you will just, what is the test of basically seeing whether a breach of duty has happened or not? So the particular test is that you will see the allegation is that X has basically been negligent in his act. Now the test will be, you will see that, okay, for example, A plus B C, infinite, these are the reasonable man in the society. And whether in the same situation, these men will also perform in the same act as did by X or not. If these men, these not just men, but these persons also would have performed the same act which X did in the same situation, then the X might not be responsible for the act to be negligent. But if these people, these reasonable persons, would have not acted in this way, but would have taken due care while performing their act, then this person will be basically charged of negligence. All right. So, what have you written? The test for the breach of duty is that it must be analyzed, it must be analyzed that whether, it must be analyzed that whether a reasonable man, a reasonable man, yeah, not right, don't write man, a reasonable person, a reasonable person would have acted differently in the same situation or not. If yes, then breach of duty exists. If yes, then breach of duty exists. Okay. All right. Now, moving ahead, consequential damages or what we call injury. Okay, consequential damages or injury. So there must be any sort of visible or provable damages to the plaintiff. Okay, then only this particular act, negligence, would be actionable in the court of law. All right. So just write. It means that there must be actual damages. It means that there must be actual damages or injuries suffered by the plaintiff, or injuries suffered by the plaintiff, or injuries suffered by the plaintiff. Okay, as a result of the breach of duty. So these can be any sort of injury. It might be physical, bodily injury, property damages, all right, or any type of financial losses. So any type of injury will be basically a part of this, all right. So right, the types of damages can vary. Full stop. It can be physical injury, comma, property damage, or financial losses. So there are certain important rules. Okay, negligence में there we have already studied in this a tort, law of tort only. There is a maxim that is injuria sine damnum. All right. So that basically maxim is tell you injuria sine damnum. Right. So in this there lies injury but without any physical damage. Okay. Now this damage must be there in case of negligence. That means this maxim doesn't stands to be right in case of negligence. For proving any other tort, that this maxim will work, but for negligence this maxim will not work. Okay, in this particular case of negligence, you will have to prove the damage. If damage has not occurred, you cannot go ahead with negligence. Okay, so write this thing: mere damage without negligence is not actionable on one side. So now negligence was there, but no damage was there. But that can be an offense, as I told you in case of basically driving the car in a high speed. Okay. Now, if you are driving the car in a high speed now, but because of that rash driving, now what happened? The any kind of damage has not happened, so no one can claim certain thing from you. But yes, it was an offense, obviously, because driving at a speed that is more than a prescribed speed by the law, it will amount to offense. It can be an offense, but not actionable under negligence. All right. Okay. So, right, mere negligence without damage is not actionable on one side, and on the other side, in negligence, and on the other side, in negligence, injuria sine damno is not sufficient. Injuria sine damno is not sufficient. Okay. That means a particular damage completes the tort of negligence. Okay. So without damage, there cannot be claimed any kind of action. Okay, with regards to negligence without any damage. Okay. Now the question is whether a particular tort of, or basically the act of negligence, is a tort only, or it can be a crime. Okay, so write this heading: negligence as a tort and as a crime. See, what it all depends on few factors. For example, cause. Okay, for example, it will also depend on the purpose. Because the purpose was basically to instill a harm and basically some greater degree, okay, then it might be categorized as a crime. But it was just a individual plaintiff specific harm, then it can be a tort. And even on consequences, so there are several factors on which this depends whether a particular act will be categorized, a particular negligence will be categorized as a crime or as a tort. Okay. Now moving ahead, we can also say one thing, that in case of negligence, okay, in case of negligence, if the demand of that particular act is basically, or I would say the effect of this act is civil liability, basically damages can be given, okay, then it will be a tort. But if in a particular case punishment must be given, then it can be basically said to be a crime. All right, when the effect of that particular negligence must be that the punishment will have to be given, okay, then it will be a crime. But simple damages or compensation will work in that case, then we can say that that particular negligence is a tort. All right, so it varies. So just write a fair introduction of this, right? The concept of negligence is not just defined or basically confined to the civil law. While it also operates, while it also operates in criminal law, while it also operates in criminal law. All right. So, right, between both there is a crucial difference. Between both there is a crucial difference of degree, purpose, and consequences. Right? In civil law, leads to compensation, while in criminal law leads to imposition of punishment. All right, the punishment can be fine or imprisoned. Right, be both. Okay, in tort, so you can also understand this in a way that if it's just, if the effect of that negligence is just limited to that particular or of ordinary type, of a smaller degree, all right, then that will be a tort. But if the effect increases and the society gets impacted from that, okay, that's a greater degree action, okay, greater degree negligence, okay, so then it will be considered as a crime, okay, so then that will be, the criminal liability will be imposed. All right, so in one case, that is Jacob Matthew versus the state of Punjab case, so you can write that also. So in Jacob Matthew versus state of Punjab case, in Jacob Matthew versus State of Punjab case, Supreme Court clearly explained the difference between criminal negligence and tortious negligence. यहाँ एक वर्ड इंट्रोड्यूस हुआ था, that was the higher degree of negligence. Okay? तो यहाँ पर लिखो, the core principle that got established by Supreme Court was that criminal liability requires higher degree of negligence than the civil liability. Than the civil liability. Okay. Requires higher degree of negligence. All right. Right, full stop and then write. Mere negligence in bracket write civil, mere negligence and in bracket write civil is not sufficient for criminal punishment. Is not sufficient for criminal punishment. Okay, it is not sufficient for criminal punishment. Okay, so now let us talk a bit about criminal negligence. All right, so just write, what is the role of mens rea in criminal negligence? देखो ऐसा समझो कि in crime, okay, just understand like this, in crime the major requirement is mens rea. All right, the major requirement is mens rea. Okay, now the point here is that in case of negligence, if it has given effect to a particular wrong which is liable for criminal liability, now the court will see whether mens rea was there or not. But now you will say that if mens rea, so for example, if the act of A has resulted in the death of B, obviously if it is because of negligence, the intention must have not been the death. Okay, it must have not been death. If the intention was of causing death to B, then A will be punishable for causing death, not for negligence. If it was a negligence, then obviously the intention was not to kill B. All right, but then what is the role of basically mens rea in this? To prove that it was a criminal negligence, first thing is that there must have been some sort of recklessness. Okay, another thing is that there must be some sort of culpable intention. There must be some sort of culpable intention in the mind of the wrongdoer that resulted into the particular wrong act, which we call as negligence. This negligence must be having some sort of criminal culpable intention. I'm not saying it was of basically causing death. Obviously, it was not of causing death. That's why we are basically categorizing this wrong as negligence, not as basically the death only. But there must be involved some state of mental state, culpable mental state. All right. Are you getting what I'm saying? Yeah. Just write In criminal negligence cases, mens rea cannot simply be ignored. Mens rea cannot simply be ignored. Okay, mens rea cannot simply be ignored. All right, right. Mens rea doesn't exist. Mens rea doesn't exist exactly according to the final criminal act that has happened. ब्रैकेट में consequence. If A, for example, now just understand this thing. If A, for example, was basically what he was doing, he was just shooting a bird. Okay. Now, being negligent, he basically did not took into consideration that some people were just going through that, passing by. He just thought that it will not, he will directly shoot that bird only. Okay, for example, or that animal. Now he was negligent. He basically did not took into consideration the consequence, okay, which can be, and he was negligent. He accidentally killed one farmer there, okay, who was basically harvesting his sowings, okay. Now, obviously, because if it is proved now that he was not having the intention to kill, obviously the intention was not to kill that farmer. That's why we are calling this act as negligence. But there must have been some sort of culpable mental state, and that culpable mental state here was to basically fire an arm and to kill an animal, which was indifferent to the consequence. The consequence is the death of the farmer. This intention was indifferent to the consequence that has happened, but there was certain some sort of criminal mental state. Okay, now write this thing.
सर मतलब वो थोड़ा सा ही अगर उसमें जैसे मेंशन करा कि है ना सम मेंटल स्टेट है तो फिर उसके लिए भी है ना उसको पनिश किया जाएगा फिर वो फार्मर की
Because
जो
वो
डेथ
mental
हुई
some mental culpable state was there and he did negligently, and basically the consequence is the harm or injury. Culpable state तो कुछ भी हो will be punished. Not just culpable state, here actors bias is also there, no?
या
Punishment will be, now it will be obviously of the lesser degree than the culpable intention of that consequence only. It will be the first and the highest degree is basically the intention. Then comes negligence. Okay. Now, even below this negligence, it is knowledge. Even you, if you didn't did any kind of negligent act, but you had the knowledge, no, that this particular act might cause some wrong. Okay, right? It exists in the form of it exists in the form of recklessness or indifference to consequence. Okay, so right, thus criminal negligence involves not just carelessness but culpable mental state. Not just carelessness, but culpable mental state. All right. So, hmm, recklessness is also very close to intention. Recklessness is very close to intention sometimes. Okay, it's very difficult sometimes to say that whether this act was reckless or intention was there. You cannot open someone's mind. You cannot open someone's brain and just see whether it was recklessness or it was negligence. You cannot do that. So recklessness is very close to intention. All right.
वैसे सर रेकलेसनेस को एज एन एक्शन के थ्रू भी तो एक्सप्लेन किया जा सकता है अगर
हाँ,
कोई
वही करते हैं फिर।
इंसिडेंट
वही करते हैं फिर। एक्शन कैसा था, है ना? दैट ओनली वी डू। लिख लो चलो क्या है, व्हाट इज रेकलेसनेस? ये बताया गया था इन आर वर्सेस लॉरेंस, एंड एक और केस था विच वाज आर वर्सेस कोल्डवेल। ओके, आर वर्सेस कोल्डवेल केस था। तो क्या लिखा अभी आपने?
व्हाट इज रेकलेसनेस
Right, as discussed in R versus Lawrence and R versus Coldwell case. Here the judges told that, see, it is recklessness is very much related to risk. There was a risk, okay? There was definitely a definite risk. You foresee the risk, but still did that action. That's recklessness, right? Right? A person is reckless when. Why are we discussing recklessness here? We are discussing recklessness here because we cannot see the intention of the person. If there was the definite intention for doing that consequence, it will be basically punished according to that. There was no exact intention. Now you are saying there was recklessness. How to basically prove how there was negligence? Now how to prove that negligence is basically to check whether there was recklessness or not. If there was recklessness, then that particular act was negligent. If there was no recklessness, then we can conclude in that case that yes, might be the case is that there was no negligence. Okay. Person is reckless when he foresees a risk. He foresees a risk. He foresees a risk and still chooses to take that risk and still chooses to take that risk. We take that risk or fails to consider an obvious risk. or fails to consider an obvious risk. All right, clear? So, right, hence recklessness implies awareness of danger or conscious disregard of danger. Okay, now nothing much to write here. Okay, now you can do one thing. You can now start negligence in law of tort. Okay, we just discussed what is negligence in crime. Okay, now negligence in law of tort. So there are basically two types of negligence. Now the question is, what are distinctive two types of negligence in tort? Okay, see, do you know that I'm discussing this as of now? So as a mode of doing any tort, okay, any particular tort. So now, for example, defamation is in itself a separate tort. Defamation is in itself. Trespass is in itself a separate tort. Nuisance is in itself a separate tort, right? For example, defamation, nuisance, trespass, these are in itself a separate tort. Now, these torts can also be done negligently. That means that particular torts, so negligence can be used as a mode of doing these torts. You getting the point? Negligent defamation. He was not intending to do defamation, but negligently, with recklessness, without taking into consideration the consequence of what you are saying, you committed defamation. Getting the point? Negligently, you were not intending to trespass someone's property. You were not intending to basically cause nuisance in any particular area or a particular place, but without taking into consideration proper consequences, even recklessly, with recklessness, you did this particular tort. Okay, so negligence as a mode of doing these torts. Got the point? And here, negligence can itself be a separate tort. How? You negligently breached a legal duty that was on you. It is in itself a tort, isn't it? Clear? So first put the first heading, then I will make you write this, then we will be moving on to the second one. Okay. So second one was basically a, there was a case, okay, a Donuk versus Stevenson case, okay, so that was basically explained in that case, okay. So but first write this, okay, so first put this heading, negligence as a means of, yeah, mode, right, mode of okay, mode of, right. In such cases, negligence is in itself not a independent tort. Okay, right. It acts as a mental element, right? Negligence here acts as a mental element in committing other torts. Examples, right? Examples: negligent defamation, negligent nuisance, and negligent trespass. Okay, right? Yeah. What is negligence here? So here the negligence is a way to do. It's basically negligence describe how that another act, defamation, is caused, whether with intention or negligently, right? It is basically describing that how that particular tort is committed with intention or with negligence. Write this line also. Negligence describes how that tortious act is committed. Right, right. Now write the next one. Okay. Uh, Negligence as an independent tort. So right, here what happens is it is separate and distinct tort. Okay, it is in itself. Now you did a particular act negligently, it doesn't mean you did another act. You did negligence in itself, right? It is a separate and a distinct tort. And focus is on conducting. Don't write that. Right, like this focus is on those conducts that creates risk. Focus is on those conducts that creates risk. Like breach of duty that causes damage. Here the negligence has resulted into such acts, but here the negligence has resulted into damages. Right. So what happens is write one definition. Okay. While writing the answer of negligence, this definition can be used. So put a heading classical definition of negligence. In Heaven versus Pender case, it was stated that negligence it was stated that negligence consists of negligence consists of the failure to use the failure to use ordinary care or skill. Ordinary care or skills, okay, towards a person to whom duty is owed. To whom duty is owed. Okay? He simply means, here the judge simply means while stating this thing, that it is our regular duty, okay, on regular basis, on day to day actions, whatever we owe to the others, it's our legal duty to take care, to take reasonable care, okay, of others also. So that's our duty, okay. And if we fail to exercise that reasonable care, okay, so then it will be considered as negligence, all right. So that is basically here written, okay. So now, for example, in also criminal cases also, na, you will see that simply if you are driving, for example, at a very fast, not very fast, but for example, the speed limit is 60 and you are driving at 80 or 100 and no damage has happened, in that case, it will be an offense, okay. But criminal negligence will come when some sort of damage happens, all right. So in this case, it will apply to doctors also. For example, the doctor, if prescribes a bit of up down medicine, all right, which doesn't causes any damage, that was also negligence but will not be punished. But if he, for example, left a medical device inside the abdomen of a patient, okay, while doing surgery, then that's gross, okay, then that will be basically, okay. So yes, all right. So now this negligence chapter is over, okay. So now we will have to start with defamation, okay. Now let us start defamation.
सर डिफेमेशन मतलब टॉर्ट्स में ना?
क्रिमिनल डिफेमेशन,
नहीं वो
टॉर्टियस
सर वो
की।
पहली क्लास डिफेमेशन की थी मेरी इसीलिए।
अच्छा ऐसा है क्या? अच्छा,
हाँ।
हाँ, टॉर्टियस डिफेमेशन। So just start this defamation. Okay, so basically what happens is, first of all, how we will be beginning with this particular chapter. So here what happens is, I will basically explain the English, first of all, the English tradition, okay, the common law thing, and then we will be moving on to basically the Indian position, okay. So here, while teaching you the English perspective, there I will make a difference. I will clear cut a difference between the libel and slander, okay. That is basically used in the English common law, okay. But then I will be moving on to the Indian one, okay, and basically we'll be discussing about there is as is no distinction, all right. So defamation, before basically starting with defamation, let us basically be clear, okay, clear on what exactly the distinction is, okay, in the British concept. Okay, so see, in the British concept, there is a position that basically it says that there are two types of defamations. All right, so the first defamation is libel and another one is slander. Okay, they basically calls it libel and slander. Okay, in the English law, there is a distinction: libel and slander. Okay, now what is the difference between libel and slander? What happens is, one word is often used in defamation, you know this, that is publication. Okay, publication here doesn't mean that you need to basically publish any defamatory statement or any word spoken or said for any person in a book or something like that, in article or newspaper. It's not like that. You know, no need to basically publish it as such. But publishing in law is simply communicating. Okay, now it means communicating. Here slander is basically, I would say, a non-permanent one. Okay, it is a publication that is not of permanent nature. It is simply that this particular defamation is a word spoken, any gesture made, or any sound, all right, which is of non-permanent character. Are you getting the point? For example, if any word is spoken, anything is said, any, so it is addressed to someone's eyes, but is basically that bends away. Okay, that is basically a slander. Okay, and in the English concept, this slander is not an offense. Okay, this is not an offense. All right. In English law, what is offense is basically the libel. Okay, which is more of a permanent character. Okay, so write a heading: distinction between libel and slander in case of tortious defamation. Okay, just write slander. Slander is the publication of a slander is the publication of a defamatory statement, in a transient or temporary form. All right, in a transient or temporary form. Okay, in a transient or temporary form. All right, right. There are various forms of slander, like there are various forms of slander like spoken word, comma, gestures, or sounds. It is not permanent or exist for a shorter period of time. Okay, देखो डिफरेंस लाइबल और स्लैंडर में ना ऐसा कुछ नहीं है कि बहुत बड़ा कोई कॉन्सेप्चुअल डिफरेंस है, ये बेसिकली बिकॉज इट इज बिकॉज ऑफ सम हिस्टोरिकल रूट्स, ऑलराइट. So this distinction has emerged due to the historical reasons, all right. So there is no as such big conceptual difference between these two concepts, okay. So now coming on to the next point here, it is no, don't write, it is don't write. Okay, it is basically moreover historical. And for example, for a movie, if there is, now just understand like this, if there is a particular gesture that is made to a person, okay, in any drama or something like that, that gesture was made and got over, all right, that defamed that person for a while. The impact might be lasting, but for that time, that was transient, that defamatory statement came and went away. That is basically, I would say, slander, okay. But for example, that full movie is based on a particular defamatory statements on a person, all right, that full entire movie or entire drama is of permanent nature and has defamed that, okay, then that will be libel, okay. So just write the libel and in bracket write permanent form of defamation, okay, permanent form of defamation. And here, right, libel is the publication of a defamatory statement in a permanent form. Full stop. It is recorded and permanent. It is recorded and permanent. And it can be seen repeatedly. It can be seen repeatedly. Okay. Right? The forms of libel: writing, printing, picture, effigies, statues. Okay. So now let us think of a case. So let's write a case about a libel in films. Okay, it's a case based on the libel in films. It is Yusupov. Okay, Yusupov versus MGM Pictures Limited. So this was a picture. Okay, so there was a Princess Natasha. Okay, and Natasha Princess, by this a person who made this film, that was basically a Metro Goldwyn Mayer. So that person portrayed some sort of immoral relations for the entire picture of uh, Natasha Princess with Rasputin. Okay, so in this picture, it was this man Rasputin was of a bad character, and the Natasha Princess was basically portrayed with having a wrong relation with Rasputin. Okay, so now it was that because of this relation which was shown, so whether it is a slander or a libel, that was the question in the UK court. Okay, now ultimately it stated that it was a visual photographic port, okay, in the picture, and basically it will be of a permanent form, that will be libel. Okay, so it also stated that the speech basically is also a part of this permanent form only, in which you can watch it repeatedly. Okay, so write this. In this case, a film was produced by Metro Goldwyn Mayer. Metro Goldwyn Mayer, that portrayed Princess Natasha, Princess Natasha in a defamatory manner. In a defamatory manner, where she was shown in immoral relations with Rasputin, who was a person of bad character. Now, right, there was a issue whether a film amounts to libel or slander, and the court held that, and the court held that the visual or the photographic part is libel, which is of a permanent form, and the synchronized speech, and the synchronized speech is also a part of some, or part of the same permanent, of the same permanent exhibition. Okay, it was observed by, case में just a lesser L, lesser L justice, that film is a permanent medium, that film is a permanent medium, and speech in film is not separate. It supports the visual. कहां तक लिखा? What was the last thing which you wrote?
सर वो लिखा था, केस की लास्ट लाइन लिखी थी, which is of a permanent form and the synchronized speech is also a part of same permanent exhibition.
Right, as observed by Slessor L. Justice Slessor L. A film is a permanent medium. A film is a permanent medium and speech in film is not separate. And speech in film is not separate because it supports the visual and is treated as libel. Because it supports the visual and is treated as libel. And hence cinema film will be libel and not slander. Okay. So this is for now over. Okay. अभी फिर इंडिया वाला केस और उसके बाद वाला वी विल बी डूइंग इन बेसिकली द नेक्स्ट क्लास. ऑलराइट, तब तक बस एक बात ये लिखो कि इस जजमेंट के बाद जो है, आफ्टर दिस जजमेंट, सो राइट, a defamation act of 1952 was also passed in Britain, which stated that broadcasting via wireless medium will be treated as publication in permanent form. ठीक है? So this will be treated as publication in permanent form. All right. So now it is over for today. So we will be continuing in the next class. All right. Sunday है class. ठीक है?
हाँ,
2
ये
to
वाले
4.
संडे को.
2 to 4 पढ़ो चुपचाप केवल इसको यार.
हाँ सर.
ठीक है? ओके.
Yes, sir. Thank you, sir.
ओके.